Welcome back to another blazing edition of Hot Topics, the podcast powered by the Suncoast Tampa Living Network, where we dig into the ideas, innovations, and real life experiences shaping business, leadership, and the future of our industry. I'm your host, Quan Rimmer, and today's conversation is one every realtor should lean into. Because when a deal gets complicated, when a dispute escalates, or when a mistake could cost real money or a license, your real estate law team is not just support, they are protection. Today, we're pulling back the curtain on how real estate attorneys work behind the scenes to safeguard transactions, mitigate risk, and help realtors navigate the moments where experience matters most. And we're recording live from Fabre Framework Studio. Fabre Frameworks, your one-stop shop for real estate photography that helps listings shine. Visit FabreFrameworks.com to elevate your next listing. Rooted right here in Tampa Bay, representing Brown and Kempton. When it comes to protecting the transaction, the title, and the client, this is not hope it works out energy. This is precision, protection, and proven experience. A seasoned real estate attorney with over 20 years in the legal field, licensed in both Florida and Texas, and consistently recognized by her peers as one of the top lawyers in the Tampa Bay area for the past 8 years. She's a director and the 2025 president of the Bay Area Real Estate Council, a leader in the real estate legal community who understands what realtors face in the field and what it takes to keep deals moving while keeping risk contained. Affiliated with the Attorney's Title Fund Services, providing residential and commercial closings, title insurance, and escrow services, which means she brings both legal strategy and closing table execution to the conversation. Her expertise spans the areas realtors actually need: real estate law, title, and lending practices, foreclosures for private investors, and asset protection and estate planning. And her impact goes beyond the transaction. She serves as the president of the Raising Down Syndrome Foundation, showing the same leadership in the community that she brings to her clients and colleagues. She is also a Tampa Bay Business and Wealth 2026 Woman Who Win finalist. And yes, realtors, she is one of the original creators of Hot Topics, helping shape this very platform we use to bring real talk to the industry. Entering the heat with experience, leadership, and the mindset to protect every moving piece of the deal. Please welcome back Barbara Brown of Brown and Kempton.
I am very happy to be back. Thank you. I'm blushing. That was quite the introduction.
Thank you, thank you. And next up from St. Petersburg, Florida, representing Rodert and Mortimer. This is where transactional precision meets courtroom strength. A real estate attorney whose practice spans real estate transactions and real estate litigation, giving him a 360-degree view of what happens when deals go right and when they go wrong. He regularly represents buyers and sellers of both commercial and residential real estate, guiding transactions from contract to closing. But his work does not stop there when issues arise, before closing or after the ink dry. He is one of the clients called to protect their interests and resolve disputes through litigation. In addition to his legal practice, a licensed title agent for First American and the fund, giving him first-hand insight into title, risk mitigation, and the mechanics that protect transactions behind the scenes. At Rodert and Mortimer, a firm known across Florida for its depth in real estate, litigation, and complex legal matters, he operates at the intersection of strategy, compliance, and protection, helping clients navigate high stakes decisions with clarity and confidence, entering the heat with experience, precision, and the ability to see both sides of the deal. Please welcome George Thurlow of Rodert and Mortimer.
Thank you. That was quite the introduction. Don't know if I've ever had such a glowing introduction before.
I'm glad. I'm glad. Well, perfect. We're going to jump right into it. So, first question for you both is going to be, many realtors think of attorneys only when something goes wrong. How do real estate attorneys protect transactions before an issue even arises?
I'll be happy to start with that. Many times, communication or a realtor thinking that they can handle the issue, bring down the escalation, or even resolve it themselves pushes it to the point where then it comes to us and the the ball has gotten too big. So we can step in the beginning, help with maybe explaining the terms of the contract, reviewing the documents, and de-escalating the situation. By bringing us on earlier, you're going to not have the end result that might have spiraled out of control. So we can look at the communication, whether it's we always look at emails are better than text messages, the more formal communication. We look at the documentation, contract. Certainly, I know we're going to talk about addendums. That's a big one.
Yes.
But then really it's the escalation. Let's make sure it doesn't escalate. So bringing the attorney on early, getting that opinion can help it not escalate to the point where you're looking at demand letters or even filing lawsuits.
I completely agree with what Barbara says. I'd say another really important thing is in contracts where there might be customized provisions. That is, paragraph 23 terms, especially if I've seen some very complicated ones or contingent closing dates. If you're going to have that kind of complex term, bringing in legal counsel from the start is going to be really beneficial because as attorneys, our skill set is writing clear contracts that if something falls through, someone can make sense of. While sometimes I've seen less clear provisions that might make sense when people are trying to make a deal, but if it has to go into a courtroom, it can make it very confusing and expensive and costly for everyone involved. The other issues in new construction transactions, I've seen a lot of custom contracts where people don't necessarily understand each provision that's not our standard form contract, and understanding what those provisions mean. And those are usually customized by builder, and having you absolutely need an attorney to prepare that because it's not a standard form contract. Other issues such as probate, if you know it's a house that's been part of an estate or someone passed away, that's a place to bring in an attorney very early because otherwise you're going to get under contract and then you're going to be stuck waiting for court approval, and that's going to delay closing and cause unhappy clients on both sides of the transaction.
Definitely.
A great example of that is just yesterday, one of our title processors brought a contract and the seller's name was owners of record. Well, there's a mistake right there. Well, come to find out, there are 6 siblings who own the property through inheritance. Well, fast forward, now they're trying to sell it, and this isn't a large transaction. This is $70,000. Well, 2 of the individuals have passed away. Both of them are out of state. So now we're looking at potential ancillary probates. But here's the biggest issue. Not all the sellers have signed the contract, not even their representatives. But it's already now come to title and we're bringing it to light. So I guess the practice point there is if you have to put on the contract owners of record, you should probably upfront order a title search. And that's one thing we do for realtors is we'll order when you're doing your initial conversation, your listing agreement, we'll order that title search at no cost so that you know what title looks like. And then the other question that should have been asked is, where are all these individuals who own the property? Their name might be on title, but if they're not alive, A, they can't sign the contract.
Yeah.
B, you're going to have to do something about them to ancillary probate, otherwise, take care of the property so that ultimately this property that's now under contract can be sold.
Yeah. Makes sense. Tell me, what are some of the most common misconceptions realtors usually have about the role of a real estate attorney?
I'll take this one. I think one of the biggest misconceptions is that attorneys kill deals and make their lives harder, and that's not our objective whatsoever. If we have our goal is to get the deal through too, because that is how we get compensated, just like realtors, and it's also causes happy clients, happy realtors, repeat business. It's our objective to close deals. So if there's something that's a hiccup, it means that it's something that's a serious problem and it's something that needs to be paid attention to. I think another big misconception is the cost involved. Certainly for closing services, title insurance is the rates are set by statute, whether you go to a title company or a law firm, and settlement services are generally competitively priced. If there have to be extra legal services, such as a probate matter or clearing a cloud on title, those are going to be required regardless of where you go. So if it's a smooth transaction, I think the cost is going to be competitive with a title company, but will already be set up to move forward if there's a hiccup along the way.
I agree. I think the biggest objection that I hear in talking with potential clients or their agents is an attorney is going to make the deal more complicated. The attorney is going to drag it out. It's going to take more time. It's going to be more expensive. Completely agree. Title insurance is promulgated by the state of Florida. We charge the exact same rates as any other title company, but we bring the expertise of years of legal experience behind the transaction so that the transaction can run smoothly. We're not more expensive, but I also think about that phrase, a penny wise, a pound foolish.
Yes.
Sometimes that addendum, or really the big one I've seen lately, is using a title company to draw up a note and mortgage. And then they've come to us to foreclose. Well, they're using a standard form out of their software. They are not thinking about default. They're not thinking about notice. Yes, it's a lien on the property, but if it goes south, you need the protection. You need the additional protection of truly knowing the terms instead of just having boilerplate terms. Most recently, one I saw had no default interest in it whatsoever. So years had gone by, they had not been paid. They got the same interest rate in the litigation and the foreclosure, unfortunately, and attorney's fees were capped at, I think it was like 10% or 5%. It was some low number, but it didn't provide for the escalation of the litigation. It went to bankruptcy. It came back. We had multiple sales that were canceled. And so the attorney's fees were substantial, but yet the form they provided didn't give the plaintiff the ability to collect everything they were owed. It was really an unfortunate situation.
It's terrible.
Yeah.
So again, that phrase of a penny wise and a pound foolish, for $1,000, they could have drafted a proper note and mortgage and really protected the plaintiff.
Yes.
Yeah, that reminds me of a case I'm currently working on where I represent a party who was a previous borrower and owner of the property who thought they were released from a mortgage and note because a title company supposedly prepared documentation, but the documentation was incomplete and apparently didn't even transfer title. So now my client has to defend a foreclosure lawsuit on a property my client hasn't owned in several years.
I've seen that too, where someone comes off of title, but they don't understand that the lender isn't party to that deed where they've transferred their title away to somebody else or the other co-owner, but yet they're still on the mortgage, and then the property goes into foreclosure, and then we get the call that says, why am I being foreclosed? I don't own the property. Well, the lender never released you. You don't own the property, but unfortunately you're still liable for the debt.
Oh, wow.
So it's just little things that can make a big, big difference. We've probably seen it all between the two of us.
Wow. Let's keep going with your experience in these clauses and things that can go wrong. From your experience, what contract clauses or omissions most often expose realtors and their clients to unnecessary risk?
Well, from the beginning, your disclosures. If you have had water damage and there's a good inspector, they probably are going to find that water damage. Mold, don't paint over it. It's going to come back. We just recently had a property in Pinellas County, And the individuals, after 4 months had been in the property, the buyers, there was the pool overflowed and the water came in the house. And when they called the remediation company to come out, the remediation company immediately turned around and said, "Oh, we know this house. We're out here every year." When it rains substantially, the water flows into the house. It was not disclosed. While a seller's failure to disclose is a hard case to prove, when you have the remediation company say, "We've been here for the last 5 years, this happens every year," that's a great piece of evidence for us. So really disclose. Yes, maybe you're going to have to reduce the price, but it's better to err on the caution of almost over disclosure than under disclosure or even trying to cover it up. Would you agree with that?
I completely agree, and I see a lot of duty to disclose type cases involving typically things like plumbing, water damage, pool pumps, those types of equipment, the types of things that someone won't notice when walking through on a showing and even on a typical 4-point inspection. And then when they move into a home, live there for a little bit, discover an issue. So I think those are a big set of issues. And then more on the contractual side, I think we see a lot of issues as well with vague or ambiguous or contradictory paragraphs in contracts, or contingent closing dates on certain events. I think those are big things, or things that might not make it clear if the building was intended to be, say, a tear down. I've had cases along those lines where the seller thought it was very clear the building was going to be a tear down. There's some indication in the contract, but it was not particularly clear in the contract. And then the buyer's like, "Oh, actually, I plan to rent it out and keep the existing structure," and you didn't maintain it. So those types of things is making sure that the provisions are clear. And if you know that your building's in bad shape, put it in the contract that you're not going to maintain it and it's a tear down. That makes it hard to bring that kind of case, which is, even if you prevail, litigation's expensive.
I think another provision of the contract is your additional terms. I mean, whether it's adding an addendum or putting some language in those additional terms. There's a big difference between the word may and must. I really would strongly recommend any agent or broker look to an attorney and have them draft those terms. Again, the penny wise, pound foolish. The documentation or the wording that goes in there can cause litigation down the road. Great example is we had a multi-million-dollar property in Pinellas County, and the language in the addendum stated that the seller would bring the dock up to code post-closing. That's all it said. We'll bring it up to code. Well, once the structural engineer got out there and once code got out there, it became a very large ticket item, which was not the seller's intentions, to the point where code pretty much said you have to rip down the entire dock and rebuild it. Well, it had a cover on it. It had a lift. At what point are we bringing it up to code versus ripping it down and rebuilding it for the buyer? That did go into litigation. Both parties had deep pockets, and it went on for a long time. Again, penny wise, pound foolish. If that agent or realtor had come back and said, draft this, some of the suggestions I would have made is put a monetary amount on it. They are only going to bring it up to code to X number of dollars. Different parameters instead of this open-ended general comment. And again, unfortunately, the realtor was brought into that lawsuit because they are the ones who drafted a very simple sentence that the seller would bring it up to code post-closing.
What should the realtors do, when the client asks us for them to just tweak the contract and move it along? 'Cause that's typically what happens.
don't do it. Just don't do it. Standard provisions are there for a reason, wouldn't you say?
I completely agree, and I think there's actually, not to sound draconian, I had a case involving a custom contract, and if doing contractual work outside of the scope of a form contract might even constitute unauthorized practice of law, which has serious legal repercussions. So I think that if it's anything more than filling out the form, you really do need to bring in legal counsel to make sure you're protected, because in that case, that was a case where the realtor was brought in as a party as well as the brokerage, because they were not attorneys. They drafted an entire contract from scratch that had contradictory and practices that didn't conform with Florida law whatsoever. And the contract was ultimately breached from my client's perspective.
Something as simple as timelines. I mean, those are standard clauses. If you don't put a date in there or a number figure, then there's a default. But take a look at those. Don't just say, oh, it's default, it's 30 days. But if your closing date is 28 days from now, but your loan approval is 30 days, you could potentially have a problem if on that walkthrough, and again, this is a case we had, on that walkthrough, they saw a soft spot in the floor. We believe that they went to the lender then said, the property doesn't conform to our use under this loan, we're denying the loan. We're at closing 28 days, but loan approval was 30 days. So they were able to back out of that contract, and then, well, they did back out of the contract, and then it was an escrow dispute. The escrow was substantial. It was a nice property down in St. Pete, and I think the escrow was $10,000 or $15,000. And escrow disputes, no one really wins. Mediators get a big chunk of that, and so it's not only adding provisions, it's looking at the standard provisions and really critically thinking about, okay, loan approval is on this date, closing is on this date, which one should I change? Which takes it to a next level. Also, if you have to do an addendum to extend the closing date, make sure you extend the other dates, because you would hate to have a loan approval, which now is prior to your closing date, and now you're into a cash contract because your dates. So
yeah, financing contingencies and period are an issue that causes a lot of follow-up. Is whether a deal has a cash, no financing contingencies, written as a cash deal and there's a last-minute lender coming in, or if it's written with a short period for mortgage approval and you don't have the mortgage approval, that's something that requires special attention across the board.
Well, take a break on that note. We'll be right back with more from our guests as we keep the conversation burning here on Hot Topics, live from Fabre Framework Studio. Fabre Frameworks, your go-to team for professional real estate photography that helps listings stand out, attract attention, and move faster. Learn more at FabreFrameworks.com. All right, it's time to turn up the heat. Welcome to the hot seat. Each of you has 2 minutes to speak directly to our realtors and tell them how your firm supports agents, protects transactions, and adds value when it matters most. The spotlight and heat are all yours. Ladies first.
thank you, Quan. Thank you for the opportunity to be here. My name is Barbara Brown. I'm with Brown and Kempton, PA. We have been in business since 2005, 2006, so going on 20 years. Bill Kempton, who is my law partner, his side of the practice is land use, variances, development, transactional. My side of the business is more litigation. With the litigation, real estate litigation, comes asset protection, probates, estate planning, in that aspect of it. We have several associate attorneys that work with us and for us as part of our team, doing everything from hard money foreclosures to sellers' failure to disclose cases. We do some unemployment law cases. Partition cases, if you're not familiar, a partition case is where two people own the property. One of them doesn't want to sell, maybe, or one of them wants to refinance, but for some reason the partnership has gone south. We draw up contracts, we review contracts, and then ultimately we are a title company. We are underwritten by First American, Old Republic, and also Westcor. So we have three very solid underwriters behind us, and they've been with us for years. So if you need a real estate attorney, want someone to review the contract, potentially have some litigation or some disputes, again, be proactive, be diligent. And certainly give us a call. Brown and Kempton, PA. We are located in the Clearwater area.
Thank you, Burr. George.
Yes, my name's George Thurla. I'm an attorney with Rodert and Mortimer PLLC, and we're in fact going to be changing our names into Rodert, Mortimer, and Thurla, as I've recently become a partner. We're a full-service civil law firm. My specialties are real estate, both transactions and litigation. I write title policies for First American and Old Republic, which is through the fund in Florida. I also help buyers and sellers through the contract stages of commercial transactions, or people who are selling land to developers, periodically those types of transactions. I also have a probate and estate planning practice, as well as provide general counsel service to businesses and nonprofits, and have a civil litigation practice that has a lot of real estate aspects, including both plaintiff and defense side and mortgage foreclosure cases, duty to disclose cases, and even things like defamation. So we really have full service, and there's some law firms that take an aspect that transactional work and litigation are very different, and we see them as inherently connected. Our goal in the transactional work is to structure your transaction so that you can avoid litigation, because we can usually prevent it through clear contractual provisions and due diligence. So I think that's really important to emphasize, and it's our philosophy. As Barbara said, penny wise and pound foolish. If you can either spend a little bit of money up front helping you get your transaction online, or a lot of money down the line on litigation. So if you want legal help and want sort of this 360 view of on how all these aspects of your life and your legal needs tie in together, you can reach out to our office. Our office is at 535 Central Avenue in downtown St. Pete. Our phone number is 727-823-4191. And it's RAHDERTLAW.com. So feel free to reach out.
Perfect. You guys did great. Let's hop right back into the questions. What are some of the situations where realtors may unintentionally create legal exposure through emails, texts, or those informal communications?
I'll let you go first.
Yes. For example, I'm representing a party in a real estate transactional dispute right now, and there's a text between, I represent the buyer, and there was the seller's realtor and the seller's principal talking about how they should squeeze the seller for more money because there's a house around the corner that was listed for a few $100,000 more than the purchase price, and saying, oh, he better not be complaining about the price, and they'd up the price, made demands for increased upgrade charges, and then there's this text talking about how he's getting such a good deal and he shouldn't care about the cost because there's this house around the corner that's listed for a lot more, and they put that in a group chat. So
I agree. It's the informal conversation that maybe because you're not in front of your computer and you're not focused, and of course, we know nobody's out there texting and driving, but it's that text message where you might slip up and say something that you might not should have, such as, my client is very motivated. That can come, in a text message, that can be, with a smiley face afterwards. That can be read different ways. We similarly had a broker contact me, and she had two individuals who were competing for the property. And she said highest and best by Monday afternoon, 5 o'clock. That was all in emails, very professionally, very formally done. But then she had text messages where she continued to negotiate the transaction until Tuesday and even Wednesday. So you've got some conflict there where you've said we've got competing contracts. We haven't signed any of them. Give us your highest and best by Monday at 5 o'clock. But yet she has text messages where she's still negotiating the contracts between the parties. Ultimately, one party won. Again, high-end property. The buyers that lost out are very upset and are now threatening to sue and tie up closing. Luckily, it's a cash transaction, but they were actually threatening to file list pendants against the property and tie up the present transaction, which I think it would have been tortious interference with a third-party contract. But nonetheless, the threat was real, and I don't think the broker slept very well before she talked to me that night because she was very stressed about the situation. So there's a big difference between sitting in front of your computer and thinking through what you're going to say versus just continuing to text message with somebody informal. And again, short bits of a text message can be read by individuals very differently. And then, of course, we all add emojis and other things to them, and you just don't know how it's read. So I really believe in clear, concise communication, diligence in your communication and documentation. Those are the two things that are so important.
That's definitely good information. Let's think about when the deal's about to fall apart. When that transaction is beginning to fall apart, what are some of the biggest mistakes realtors make before calling an attorney?
I think trying to fix it themselves. I think inherently human nature is, let me help my client. I'm not talking from a legal standpoint, my client, but I'm talking from a realtor standpoint. Let me help my client. Let me try and de-escalate the situation. Many times that can cause it to actually get worse. Maybe now the conversation becomes even more convoluted. So I think that's where they really need to step back, say, let's de-escalate. I'm already involved, i.e. the realtor, I'm already involved, the agent, broker, whomever. I need to step back. I need to bring in a third party. I need to bring someone in who's looking at it from a higher level in the sense of looking at the entire transaction.
I completely agree with that. And I'd say, in terms of sort of warning signs and when to maybe start having that conversation, I think one telltale sign is you see this especially in commercial transactions where there might be due diligence benchmarks. And if you start seeing, if you're a seller and start seeing a buyer miss some of these benchmarks, not get a surveyor, not apply for land use changes timely, which are often contingencies in commercial contracts, at that point, that's probably a good opportunity to start talking to an attorney. It might be nothing, but you might need to be prepared for a dispute about to arise.
I think that's true in residential contracts too. When someone starts missing deadlines or even not responding or, goodness, ghosting, those are some of the warning signs that something else is going on. Reading, I want to say reading between the lines to some degree, saying, okay, is the buyer up to something? Is maybe financing not going to work? Why aren't they responding? Why have they missed this deadline, etc.?
Yeah, I'd completely agree with that. And I'm thinking about my parents selling their home a few years ago, and they were selling to someone who just disappeared for a few months. Eventually, the deal got closed, but it took attorney intervention to send an acceleration, and time is of the essence letter saying, you need to close this. You've missed 3 deadlines. No one's heard from you for weeks at a time.
Wow. How can realtors build stronger working relationships with attorneys to, better serve their clients and protect even their own businesses?
Well, build the relationship. Get to know an attorney that you feel comfortable with and build that relationship. And many times, attorneys offer different types of education, whether it's in their office or podcasts such as this. I know we do a legal tip every Tuesday on our Facebook page. I try and do it every Tuesday. I try very hard. But like this past Tuesday. I'm trying to figure out what day of the week it is. We did one on homestead. And one question we get many times is, why does my spouse have to sign, whether it's the deed or otherwise? Just recently, we had a closing where a woman came in and she brought a gentleman with her, and my closing agent said, "Oh, and who is this?" And she said, "Well, this is my husband." Well, the transaction, even on the 1003 with the lender, said she was single at all times. So transaction had to come to a halt, and it closed about 2 or 3 days later. But clearly, the understanding of homestead and why a husband and wife that are on property both have to sign the deed. Recently, we had another similar situation where a gentleman was coming to us. He was in the midst of the divorce and said, "I just want to do a quit claim deed over to my wife." And I said, "If it's your homestead property, it's of no consequence. You cannot deed your home away if you're still married." We see that mistake made quite a bit when people do their own divorces. That deed is not good until it says a single man and a single woman, as opposed to husband and wife.
Yeah, I would completely agree with that. And I'd actually encourage a lot of realtors to form relationships with multiple attorneys, because you want ones who you can refer your clients to in situations. But you also need to be prepared if something comes between you and a client, that you might want to have your own independent legal advice as well.
What should realtors look for when selecting or referring a real estate attorney to a client?
Reputation, how long they've been practicing. We're both seasoned attorneys here. What their areas of practice are. You might even have a bank of 2 or 3 attorneys. You might have one that's really probate. If you have a situation where you have someone who passes away, someone who's transactional, someone who's more of a litigation attorney. A lot of firms now have, brought all of that in-house. I think both of our firms have done that, which, that's creates a one-stop shop. So that's very nice. But I think the big thing is looking at someone's integrity, reputation, their background, how long they've been in practice, and then ultimately asking them the hard question: have you ever dealt with this situation?
Cool.
And if they say no, then maybe you want to go to somebody else.
Yeah, I would agree with all of that. And I think there's a sort of a cliche saying that some attorneys make deals, other attorneys kill deals. So you sort of have to look at the objectives in a situation. Do you want someone who can try to help make a deal in a difficult situation, or do you want someone who's going to fight scorched earth and maybe blow up a deal? I'm not saying one is the right or the wrong way, and it depends on the context, but you might want to think about that. And I think having a bank of attorneys for different kinds of specialties, I think, yeah, probate, transactional, litigation, land use, those are probably going to be some of the most common issues that realtors face. But I recently had a client face a situation where a real estate commission got caught up in a bankruptcy dispute. So you might want to know a bankruptcy attorney, because if you're representing a client in bankruptcy, you as the realtor have to get approved your employment by the bankruptcy court.
Wow.
And you potentially have to get the transaction approved by
yes,
the bankruptcy court.
Both.
Another example, I just had this the other day. I do quit claim deeds, although they're not the favored. We try and do more warranty deeds, but we had someone call us and ask if we can do a quit claim deed on a timeshare. I honestly told them I have never done a quit claim deed for a timeshare. daughter wanted to transfer the property, the timeshare interest, to mom. And so I said, do deeds all day long, but I'm not specialized in timeshares. I'm not going to play in the sandbox because I don't know what I'm doing, but let me find somebody for you. And I went down to my partner, Bill Kempton, and I said, do you know anybody that does timeshares? And I said, yep, we've got a guru. And we turned, the client over to them. But
Nice.
that's where, again, having different attorneys or having that attorney who's willing to say, I've never done this, but let me help you find somebody to do it. I don't want to create a problem, and certainly I would hate if I thought I could do that quick claim deed for that person to come back years from now and say, it really didn't transfer the interest. You didn't use this magic language. In the legal field, so many times there is magic language that has to be used.
Gotcha. What types of legal issues are becoming more common in today's real estate environment that realtors should be especially cautious about?
I'd say those duty to disclose, which we've talked a lot about already. I'd say those cases are becoming progressively more common. And my best piece of advice to realtors generically is make sure that your clients tell the truth, and they shouldn't guess on a disclosure either. If it's a case where someone say it was their mom's house and it's been through probate and they don't know the history, I don't know is the answer, not I'm guessing that this issue hasn't happened before.
I would agree. On a seller's disclosure, it's yes, no, I don't know. End of story. No assumptions, no guessing, etc. So I would agree with that.
I do have a question I'm thinking of right now. Let's say that an issue was known, it got disclosed from a previous inspection, and then it gets corrected, and then a new deal comes through. Should the seller disclosures be updated to reference that previously known situation, even though it's been rectified?
Both of us are over here nodding our head. My response is absolutely disclose that, hey, we had a water leak or a pipe burst or a leak in the roof. We fixed it. Here's the information. And by the way, here's the warranty that the work was done by a licensed, reputable contractor. Be upfront because it's a better situation. And you can comment on this from a litigation standpoint, if you come up and say, no, we disclosed this to you. We disclosed that there was a leak. So therefore, if you felt like there were some concerns about that leak or even had a funny smell in the house, you're now on notice to possibly do a mold testing of some sort. So it leads it down the road to they are now informed, and they can take additional steps and maybe bring in their own inspector to take a second look at something.
Yeah, I mean, a really good lesson in this is a former colleague of mine many years ago sold a property that had a sinkhole on it. And he disclosed it as part of the contract, had some engineering and soil tests done, provided that to the seller. Several years later, he got a phone call from an attorney when the issue reemerged. Because he had all this documentation, that phone call was the end of it for what was a fairly significant issue. And in terms of plumbing repairs, that kind of thing, I recently had a case where someone had to call a plumber on an emergency basis on a Friday night, canceled their open house the next day, so they let their realtor know about it. Fast forward, my client bought the house several weeks later, put it under contract, bought it. There's a system-wide pipe clog, had to replace all of the pipes in the house, which required to take out the flooring. That was a $35,000 repair on a fairly modest home.
I felt that. Oh man, it hurts.
It's all about, if you disclose, then you put them on notice. And that buyer now, it's the burden shifts to that buyer now to do their additional due diligence. But if they don't know, they don't have that opportunity to do their due diligence. And that's where ultimately the problem arises, with either a seller's failure to disclose or some kind of negligence. And no realtor wants to be dragged into that suit, whether they're being named as a party because they knew that the open house had been canceled because of a pipe bursting and didn't disclose it to anybody, or did not have the seller's disclosures updated. I would probably bring them in if I had that evidence. Or just having to waste your day answering interrogatories or requests for production, or even being in court to testify.
Yeah, attending a deposition, preparing affidavits.
Yeah, you don't want to be in of all that. That sounds rough. All right, it's good.
But we enjoy doing it. So.
Yeah.
If a realtor could take one proactive step today to reduce the legal risk tomorrow, what would you recommend?
Don't guess things. Don't assume things. If you don't know something, try to seek guidance, whether it's from your broker, and if you need to if it's a legal question, contact an attorney to get advice. And we're generally happy to try to point you in the right direction and figure out a way to solve the problem and keep everything on track.
Well, I've done this before, so I love little acronyms or little letters.
Yes.
So I call it your CDE, or clear, concise communication, documentation, document everything, and then escalate. The minute you have that gut feeling of, I need help, or I need more information, or something's not right, whatever that red flag is, escalate it. Escalate it to your broker. They've been in this business for years. Maybe they've encountered it. If they haven't, escalate it to an attorney in that field, in that area, and ask the questions.
Perfect. Well, a big thank you to Barbara and George for bringing clarity, experience, and straight talk to today's conversation. And to our realtors listening, remember this: a strong real estate law team is not just for emergencies. It's a strategic partner that helps protect your deals, your clients, and your career. Download, subscribe, and share. Turn on notifications so you never miss the heat. More expert guests, real talk, and game-changing insights are coming your way on Hot Topics live from Fabre Framework Studio. Fabre Frameworks specializing in professional real estate photography that helps listings stand out, attract buyers, and make a powerful first impression. Learn more at FabreFrameworks.com, the official studio home of Suncoast Tampa Living Podcast Network. And this is your host signing off. Until next time, keep pushing boundaries, delivering value, stay protected, and standing out like the star you are.